Hello friends, welcome to the July week 2 current affairs video. As I have mentioned in my previous video, I have divided the weekly current affairs course into a 4-part video. This is the first part which deals with the national and economy news section. So the first news under the national section that we are going to see is about the Chief Justice of India as the master of roster. Now, what is a roster? It is a list that contains people's name and the jobs they have been given to do. In the judicial context, it says which case will be heard by whom or which bench. So, what does master of the roster mean? It refers to the privilege of the Chief Justice of India to constitute benches to hear cases. That is, it is the Chief Justice of India who decides which case will be heard by whom or which bench. That is, the Chief Justice of India alone can assign work to a judge sitting alone or to the judges sitting in division or full bench. So what happened is former Union Law Minister Shanti Bhushan filed a petition stating that instead of the Chief Justice of India, the power to allocate cases should be given to the Collegium of Supreme Court Judges collectively. So we know that the collegium system deals with the appointment and transfer of judges, which is the outcome of 3 judges case. So please remember that with respect to the appointments to the Supreme Court, the collegium system comprises of Chief Justice of India along with 4 senior most colleagues. At the same time, with respect to the appointments to the High Court, the collegium system consists of the Chief Justice of India along with 2 senior most colleagues. Now, why that the collegium has to take over this responsibility? This is because the power in the hand of one person may end up being an absolute, singular and arbitrary power. And earlier, if you remember, the Chief Justice of India Deepak Mishra and some of his predecessors were criticized by his colleagues for allocating cases of national importance to select judges. So while hearing this petition, the Supreme Court has reaffirmed that the Chief Justice of India is the master of roster, and it declined to accept former Law Minister Shanti Bhushan's suggestion that the CJI consult his collegium colleagues in allocating cases to various benches. And it has also observed that neither the Article 145, which deals with the rules of court, nor the Supreme Court rules say the Chief Justice of India as the collegium. Thus, it is the exclusive authority of the Chief Justice of India to allocate cases to fellow judges in his role as the master of the roster. So with this verdict, this is the 3rd time in 8 months the Supreme Court has declared its Chief Justice as the master of roster. Earlier 2 times being in November 2017 while hearing a medical college corruption case, that is the Prasad Education Trust case, and the 2nd time in April 2018. Let's quickly see the Supreme Court's observations with respect to this petition. The Supreme Court has observed that the Chief Justice of India is the master of roster in allocating cases to different benches, and his power cannot be delegated to collegium. Supreme Court highlighted that the CJI owes a moral responsibility to his colleagues and the public at large while flexing his powers as master of roster to allocate cases. The court also listed some of the qualities a Chief Justice of India should possess while performing his role as the master of roster, which includes balance, fortitude, moral courage, and independence of mind. Also, as the court's spokesperson, it is the Chief Justice of India's duty to usher in and administer reform as a continuous process. The next one is about the National Testing Agency. The National Testing Agency was approved by the Union Cabinet in November 2017. It is a premier, autonomous and self-sustained testing organization which was established to conduct entrance examinations for admission or fellowship in higher educational institutions. The NTA will be chaired by an eminent educationist appointed by the Ministry of Human Resource and Development. The objectives of the National Testing Agency are to conduct efficient, transparent and international standards test in order to assess the competency of candidates for admission and recruitment purposes, to undertake research on educational, professional, and testing systems, to identify gaps in the knowledge systems and take steps for bridging them, to identify experts and institutions in setting examination questions, to produce and disseminate information and research on education and professional development standards. So, the NTA is set to conduct the entrance examinations for higher educational institutions from next academic sessions onwards, starting with the UGC NET exams. So, the NTA is taking over the responsibility to conduct exam from CBSE. Also, for the first time in history of the competitive examinations, the JEE mains and NEET will be conducted twice a year instead of just once. Thus, it gives flexibility for students and also a chance to students who misses the exam due to an unwarranted circumstances. Also, the students can take these exams twice and their better score will be considered for admissions. So, the National Testing Agency conducts the Joint Entrance Examination Test, that is the JEE mains, the National Eligibility Cum Entrance Test, NEET, the Common Management Admission Test, CMAT, the Graduate Pharmacy Aptitude Test, that is the GPAT, and the UGC NET National Eligibility Test. The next news is about Section 377 of IPC. It is a colonial era provision which says that whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So, in short, this provision declares that sexual activity between people of the same gender is illegal. So, thus it criminalizes homosexuality. In the past, many petitions were filed challenging the constitutionality of Section 377, in which people argued that this provision has to be scrapped as it violates the fundamental rights guaranteed by the Indian Constitution. Now, why it has to be scrapped? Why does it matter? Section 377 criminalizes a section of people for being a sexual minority. So, this includes the LGBTI community, that is the lesbian, gay, bisexual, transgender, and intersex people. These people in India face discrimination and legal and social difficulties because of this section. And they argue that the right to sexuality, sexual autonomy, and freedom to choose a sexual partner form the cornerstone of human dignity. Thus, Section 377 has a chilling effect on the right of equality, liberty, life, dignity, and non-discrimination on the ground of sex. So, thus, it violates the fundamental rights guaranteed under Article 14, 15, and 21, and that's why it has to be scrapped. Now, seeing this from the other end, there is a section of people who are in favor of Section 377 and they don't want it to be scrapped. And the reasons that they give for that is homosexuality is against the law of nature, it is against the norms of society and religion, and also they cite a scientific truth that homosexuals are more prone to sexually transmitted diseases like AIDS, etc., than any normal person. They also say that decriminalization of Section 377 may further decline the country's sex ratio if more people adopt for homosexuality. Let's see the important judgments related to Section 377. In 1862, Section 377 came into force. In 2001, NAS Foundation files a writ petition in Delhi High Court challenging Section 377. With respect to this writ petition, the Delhi High Court passes a landmark judgment in 2009 in this NAS Foundation vs. Government of NCT of Delhi case by decriminalizing Section 377 and describing it as a violation of the fundamental rights guaranteed by the Constitution. So, thus the Delhi High Court judgment protected the LGBT community from Section 377. Following this verdict, 15 special leave petitions were filed in the Supreme Court on behalf of religious groups from all parts of the country. With respect to this, the Supreme Court in the year 2013 overruled the Delhi High Court's order in this Suresh Kaushal versus Nas Foundation case, stating that the Parliament should debate and decide on this matter. Thus, it reinforced criminalization of homosexuality by upholding Section 377. Moving to a different case that has nothing to do with Section 377 directly, but its verdict gave a new hope to the LGBT community to uphold their rights. This case is Justice K.S. Puttaswamy versus Union of India. So in the year 2015, a bunch of petitions were filed in the Supreme Court challenging Aadhaar as a breach of privacy. As part of this case, in the year 2017, a 9-judge constitution bench of Supreme Court on August ruled that right to privacy is intrinsic to life and liberty and is inherently protected under the various fundamental freedoms enshrined under Part 3 of the Indian Constitution. So following this right to privacy verdict, flood of writ petitions filed to scrap Section 377. This is because one's sexual orientation is undoubtedly an attribute of privacy. The right to privacy and the protection of sexual orientation lie at the core of the fundamental rights guaranteed by Article 14, 15 and 21. So in July 2018, a constitution bench led by Chief Justice Deepak Mishra reopened the entire issue, saying a section of people could not live in fear of the law which declined their rights to choice, privacy and dignity. On July 2018, a 5-member constitutional bench of the Supreme Court commenced hearing of the pleas challenging Section 377, in which the court observed that the choice of a partner is a person's fundamental right and it can be a same-sex partner. And the Supreme Court drew this observation from Hadia case. And Hadia is a Hindu girl from Kerala, converted to Islam and chose to marry a Muslim man. In this March 2018 judgment, the Supreme Court held that neither the state nor one's parents could influence an adult's choice of partner. That would be a violation of the fundamental right to privacy. So the bench ended its marathon hearing and the verdict has been reserved related to Section 377. And in a surprising move, the Union government has said that it is not going to take any sides on this issue and it is going to leave the decision to the wisdom of the court. Now what's next? The pertinent question before the court is, what is the order of nature meant by Section 377 in its text? So once the Constitution bench decides that homosexuality is also an order of nature, then other larger issues related to homosexuals could be addressed, such as legalizing same-sex marriages, inheritance, adoption, and reservation in employment. Moving to Section 497 of IPC. In India, the offence of adultery is punishable under Section 497 of IPC, and adultery is nothing but a voluntary physical relationship between a married person and a person who is not their spouse. So this section says that whoever has a sexual intercourse with a person who is and whom he knows or has reasons to believe to be the wife of another man without the consent of that man, then such sexual intercourse not amounting to the offence of rape is guilty of the offence of adultery and shall be punished with imprisonment which may extend to 5 years or with fine or with both. In such case, the wife shall not be punishable as an abettor. Breaking it down, this section says any person who has sexual intercourse with the wife of another man without the consent of that man shall be liable for the crime of adultery. So say that Mr. X is in a physical relationship with a married woman without her husband's consent, then Mr. X shall be punished for the crime of adultery. Thus, the statutory provision reflects how women are considered mere possession and property of the husband, as here the emphasis is laid on the consent of the husband. The second point is only sexual intercourse with a married woman would amount to adultery. So again say that Mr. X is in a physical relationship with a widow or a sex worker or an unmarried woman, then he would not attract this section. This has been confirmed by the Delhi High Court in the case of Brijlal Bishoni vs. State 1996. Thus, it draws a distinction between consent given by a married woman without her husband's consent and a consent given by an unmarried woman. The third point is, in case the offense of adultery is committed, the husband cannot prosecute his unfaithful wife but can only prosecute her adulterer, as the section itself expressly states that the unfaithful wife cannot be punished even as an abettor to the crime. That is, once the offense of adultery is committed, the husband cannot take legal action against his wife even as an abettor, that is, as a partner in crime. And the husband can only prosecute her adulterer, that is Mr. X. So the offense of adultery therefore is an offense committed against the husband of the wife and not against the wife. Thus, as per the Indian law, a woman cannot be punished for the offense of adultery and has been in limelight for being discriminatory towards men. And the fourth point is, the provision does not confer any right on the wife to prosecute her husband for adultery. It means Mr. X's wife cannot prosecute her husband for adultery. A 5-judge constitutional bench has been constituted by the Chief Justice of India to decide upon the constitutionality of Section 497. The purpose of this hearing is to consider whether Section 497 would treat the man as the adulterer and the married woman as always a victim, and it also about to examine whether the pre-independence provision of adultery treats a married woman as a commodity owned by her husband and violates the constitutional concepts of gender equality and sensitivity. With this, the Constitution bench will re-examine a consistent view dating back to 1954 that adultery as an offense should be retained in the penal code to uphold family ties. Opposing a plea which called for the Section 497 of the IPC to be scrapped, the centre recently told the Supreme Court that adultery must remain a punishable offence as Section 497 supports, safeguards and protects the institution of marriage. The next one is about the Eat Right movement. The Eat Right movement is led by the Food Safety and Standards Authority of India, which aims to empower the citizens by improving their health and well-being by cutting down the salt, sugar and oil consumption by 30% in 3 years' time. It is built on 2 broad pillars of eat healthy and eat safe. It also aims to engage, excite and enable citizens to improve their health and well-being by making the right food choices. So the Food Safety and Standards Authority of India has unveiled the Eat Right movement with a view to get industry on board for implementation of Draft Food Labelling Regulation, which is the Food Safety and Standards Labelling and Display Regulations 2018. It is a proposed draft regulation which will prescribe the labeling requirements of prepackaged foods and states that HFSS, that is the high in fat, sugar or salt food products, shall not be advertised to children in any form. It also introduces labeling of genetically modified food. About FSSAI, it was established under Food Safety and Standards Act of 2006 and it is a nodal statutory agency responsible for protecting and promoting public health in India through regulation and supervision of food safety. It was created for laying down science-based standards for articles of food and to regulate their manufacture, storage, distribution, sale and import to ensure availability of safe and wholesome food for human consumption. And the ministry that is the head for the implementation of FSSAI is the Ministry of Health and Family Welfare. The chairperson and the chief executive officer of FSSAI are appointed by the Government of India and the chairperson is in the ranks of secretary to Government of India. Under the economy section, we are going to see about the European Bank for Reconstruction and Development. India has joined the EBRD as the 69th shareholder, paving the way for more joint investment with Indian companies across the EBRD's regions. India had applied for its membership in December 2017, and the Board of Governors of EBRD, which represents all existing shareholders, voted unanimously in favor of the country's application in March 2018. Here, India takes a shareholding in the EBRD, but it will not be a recipient of EBRD financing. But it may benefit indirectly through the bank's project, or if Indian companies invest alongside the bank. About EBRD, it is a multilateral developmental investment bank which was established in 1991 after the fall of Berlin Wall to promote private and entrepreneurial initiative in emerging Europe. It is owned by 67 countries from 5 continents as well as the European Union and the European Investment Bank. The headquarters is in London, United Kingdom. It invests in 38 emerging economies across 3 continents with a predefined set of criteria that aim to make its countries more competitive, better governed, greener, more inclusive, more resilient, and more integrated. Investing primarily in private sector clients whose needs cannot be fully met by the market, the EBRD promotes entrepreneurship and fosters transition towards open and democratic market economies. The mandate of the EBRD stipulates that it must only work in the country that are committed to democratic principles, and also respect for the environment is part of the strong corporate governance attached to all EBRD investments. That's it with this video, friends. Thank you for watching. Please like, share and subscribe to my channel, and do make use of the comment section. We'll meet you soon with the part 2 video. Until then, have a great day. Bye bye.